Okay, in this video, we're going to talk about when not to attempt to protect your assets from nursing home expenses. All right, so I'm Paul Rabley. I'm an estate planning attorney. I help our clients get and keep their legal affairs in order. The biggest threat to the estates of the middle class these days, it's not taxes. People can pass away with and have up to $11.58 million, and there'll be zero of the 40% estate tax. It's not so much children or survivors fighting over the estate. That happens in some circumstances, and when it happens, it's a mess. But really the biggest threat to the estates of the middle class is getting sick. People are living longer, medicine is doing things that allow people to live longer, and they're more likely to need that long-term care in the future. Somebody turning age 65 today has a 70% chance of needing long-term care in the future. And that care is expensive. So when someone gets sick and goes into a skilled care facility, a nursing home, they have to spend all of their assets down at, plug in your number of the rate of the nursing home in your area. I'll say $7,000. If you're a married couple, you'll spend $14,000 per month until you have really nothing left. So that's the biggest threat. And so many people these days, they come into my office, Paul, I want to protect my land, my farm, my office building, fill in the blank. That they say, I don't want to, if I get sick, I don't want to have to sell that and spend it on my care. I want to protect it. And so, or maybe they say, I want to protect the value of my home because I heard that if I go into a nursing home and I qualify for Medicaid, then when I die, Medicaid has a lien on my house. They can pursue their estate recovery rights. The home gets sold, pays Medicaid back for what they spent on my care. I don't want to do any of that. I want to protect it for my family. Okay, so they might say, I want to put on my property, my land, my farm, my house, I want to put it in my kids' names, or I want to put it in whatever kind of trust I need to put it in so it's protected. Let's do that. And so whenever we have a discussion about trying to, quote, protect assets, we always have to have a more thorough discussion about what else the individual owns. So let's say Larry has, maybe he does have some land or farm or an office building that he wants to protect. And, maybe it has some sentimental value. Maybe he has a farm or some land that, kids and grandkids can play on. And that's really what's driving him to want to protect that. Because it's an asset that has not only fair market value, but it has sentimental value to him and his family as well. So the conversation turns to, well, Larry, besides that property that you want to protect, what else do you own? And, Larry will say, I have my checking account, I have a little bit in my savings, I have my truck. And then I was like, what else do you own, Larry? Well, I've got my IRA. What's your IRA worth? Well, my IRA, last time I checked, it was worth about $1 million. And let's say Larry's 69 years old. Larry, what's your plans as far as distributions from your IRA? He's like, no brainer, I got that covered. Required minimum distributions under the new rules start when I'm 72. I don't like paying taxes. I'm only going to take my required minimum distributions. I'm not going to need any more income than that. That's what I'm going to take. So, he's set, just like most people, it's just drilled into their head, only take the required minimum distributions. And so at that point, the conversation turns to me asking Larry a question. Larry, regarding this protection and of what you have, do you want the blunt version or do you want the sugar-coated version? And Larry says, I want the blunt version, give it to me straight. So I'll say, well, Larry, I'll say something like this, and I'm going kind of fast here, but I'll say something like this is, Larry, you mentioned you wanted to protect your land, your farm, your office building, whatever. But the blunt version is, Larry, you're never going to be, under your kind of current plan, you're never going to qualify for Medicaid. You have to expect to be a private pay patient if you need long-term care in the future. You're not going to qualify for Medicaid. Yes, you may get your land and this valuable, both fair market value and sentimentally valuable piece of property out of your name because you want to protect it. But with your $1 million IRA and with you only taking those required distributions, let's say when you're 72, the required amount that you have to take out of your IRA is 4%. You'll take that 4% out, $40,000. You'll be left with $960,000 by the time you get around a year later to take another required minimum distribution. Who knows what your investments will do, but it is not out of the realm of thinking that that $960,000 may grow up to $1 million or more by the time you take the next required minimum distribution, and it all starts over again. So Larry, You're never going to have less than $2,000 in your name. You're never going to be a Medicaid recipient. You need to expect to be a private pay patient. So why try to protect this land if the getting it out of your name is not going to do you any good anyway, because you're never going to qualify for Medicaid because you're always going to have that IRA in your name. Can't get an IRA out of your name without taking it all out and paying the income taxes first. And you are, very adamant about only taking the required minimum distributions. I wouldn't have quite said it that way, but would have said something like that. And from that, Larry may say, I'm still only going to take my required distributions because I am adamant that I only want to pay the minimum amount of tax that I have to and let the rest grow tax deferred. Or maybe he'll open up, I doubt it, but maybe he'll open up to taking more than the required distributions, paying more tax than he would otherwise have been required to so soon, and start protecting some of that money as well, but probably not. So he probably would have said, I get it. I'm always going to have my IRA, and so yeah, I'm not going to be a Medicaid patient because I'll always have that IRA. And I guess there's a possibility that he could, have a stroke when he's 73, go into the nursing home immediately and spend 20 years or more in the nursing home. And yes, he perhaps would spend down all of his IRA on his care from $1 million down to less than $2,000. But at the time that he has the stroke, perhaps his family can do things to protect the land then, or at least start that 5-year look back period, because it's going to take at least 5 years for him to spend the IRA money, or at least 5 years to protect the IRA money when he has a stroke by taking all of the money out and paying income tax, which nobody wants to do, and then trying to protect those after-tax proceeds. So my point is, it doesn't do much good to kind of, quote, protect one asset when you're leaving another significant asset in your name. The protection really doesn't take effect until you get everything out of your name, or everything but a little bit out of your name. Start that 5-year period running. So at some point in the distant future, if you go into a nursing home and when you or a family member on your behalf applies for long-term care Medicaid and they ask you, have you transferred anything out of your name in the last 5 years? You want to be able to say no to that answer, to that question. That's the only way you'll be potentially eligible for long-term care Medicaid. So that's my point, is don't piecemeal this kind of Medicaid protection. Either do it full speed or don't do it at all. Don't impose the restrictions on yourself that are required when you protect an asset, when protecting that asset doesn't do you any good long-term, because you have all these other assets that would never enable you to qualify for Medicaid to begin with. Now, there are some other reasons why people do get proactive on the estate planning legal program side that may not have anything to do with this long-term care Medicaid protection. Before I get into that, let me just remind you, make sure you punch the subscribe button, punch it hard, and then click the notification bell. That way you don't miss anything as I provide more educational estate planning videos. Some of the other reasons people will, be proactive in trying to protect what they have is they may want to put their land, their property, their farm in a revocable living trust, still a countable resource, but may do that to make it easier for their survivors to get it when they pass away, so they won't have to go through the court supervised and attorney involved probate process. Maybe you want to put your property in a trust so that it's more likely to be kept in the family after you pass away and the kids don't lose it to divorce, a forced sale, sibling rivalry, whatever the case may be. So there's still a lot of reason to be proactive and engage in an estate planning legal program, but you just have to be real careful about trying to, quote, protect from the nursing home one asset when it's very unlikely that you'll ever be able to qualify for Medicaid because of an IRA that remains in your name, probably for the rest of your life or for many, many years into the future. Okay, and then the last thing I'm going to go over that's real important is 10 a.m. Central Time every morning. Check out my YouTube video. New stuff every morning. And then also smash the thumbs up button. That would be awesome. And hey, if you want to do me a favor, click the share arrow and then by email or text, share this video with somebody else who might be a little worried about if they get sick, they don't want to lose everything in the future. Okay, so see you tomorrow.